just having the words on the paper doesn't really mean anything at the end of the day. It's how you can, present them to a court, how you can persuade a judge, how you can persuade a jury that really matters. And someone who has a litigation background as well, that, as a lawyer, I like being hired and handling this, but there's a way to avoid it, and that's the smart way to do it. That's what you should be doing as a construction company, as a lawyer for construction companies. You need to really look at how this is going to be interpreted in court. And the owner is delinquent on payments to them, then your subcontractor is going to be forced to continue performing work without being compensated. And that's when delays happen, that's when defects happen, that's when a lot of issues occur. Does that mean that the plumbing contractor now has agreed the scope of their work is to make sure all trades complete all work necessary? I mean, between you and I, the answer is no, but between the court, every court in the country likes to enforce contracts as written. And they're going to come into court and say they knew that their obligation was to make sure the building got this substantial completion. Some contractors may be a little greedy. They may try and fudge it so some scope work is they can classify as change order work, and the initial decision maker snuffs that out, doesn't allow that. But when it's legitimate, the architect or engineer, whoever you choose, is going to say this is a legitimate change order. But again, just know your jurisdiction, know your amounts, and make sure you're very, very specific, and take your time and to really categorize and figure out what you're owed and what you're not owed.
Welcome everybody to the Mobilization Mindset. My name is 𝗍𝗶𝗃. I am the CEO and founder of Mobilization Funding, and today we're going to dive into construction contracts, specifically the GC and subcontract relationship. The contracts you guys use, the AIA documents, lien releases. We're going to talk about how to make those contracts better for you, the project, the subcontractor, and the general contractor, conversations you can have, and much more. We're going to do it in a simple, easy way so you can get your pens out, take some good notes here. And today I got a great expert. Jason Kosek, who is a shareholder at Anderson Kill, is going to walk us through this. Jason, welcome to the show.
Thanks for having me, Scott. I'm excited to be here.
Me too, man. Me too. Let's dive right into it. I want to hear, give us a little background on your construction law experience. We know when you and I talked originally, I found you greatly interesting one, you're very conversational, so it was awesome to talk to, but you took down these basic principles that I see and we hear about from subcontractors and GCs all the time that they're continuously kind of going back and forth on, and you were able to break those down. So just give the audience a little bit of your experience in the construction realm.
So I've been practicing construction law for about 12 years now, almost exclusively in my practice. I'm a litigator through and through. Most of my time is spent in court, but through litigation, a lot of the times you're litigating the contract, terms of the contract, the agreement, and usually you're stuck with a contract that you didn't draft, and that gives you the mindset to be able to figure out how the contract could have been improved in order to better protect your client, whether the client is a subcontractor, a general contractor. You learn what provisions work, what provisions don't work, and you can learn to exploit the ambiguities that may exist and how to redraft them in a better way to serve protection. So, like I said, I've been practicing for litigation for about 12 years. I've been drafting construction contracts for probably about 10. I've drafted contracts for projects in New York City, for projects in Florida, and some in New Jersey. So I've drafted contracts that have been used all over the country, and just really, I got the one thing I would say is that really it's all about getting a transactional attorney who can draft your contract, who has that litigation background as well, because just having the words on the paper doesn't really mean anything at the end of the day. It's how you can present them to a court, how you can persuade a judge, how you can persuade a jury that really matters, and someone who has a litigation background as well really can help hone your contracts to being a much better shield and sword for your company.
I love that. And when you what's your major practice built on? Is it built on all aspects of the construction circuit, from the general contractors to the subcontractors, owner, developers? Where have you fit in the waterfall, so to speak?
I've represented everyone. I've represented owner, developers. I've represented GCs. A lot of my experience recently has been with larger contractors who then have their own subcontractors, and then I have to coordinate a lot of times the contract between a contractor and a GC will require terms for that contractor to include with their subcontractors. So you have to really make sure that as you're drafting a contract for a contractor for one of its subcontractors, you include all the mandatory terms that the GC contract requires. So it's kind of making sure you're aware of everything and being on top of the game and being organized, which is key number one to being, drafting proper contracts.
So I'd say in the majority of in our mobilization funding world, most of our clients are typically utilizing some version, if not the standard version of the AIA subcontract. In your experience, what do you think is the few clauses or the number one clause problem issue that kind of arises in there that if worked on beforehand or if negotiated in some manner differently could prevent a lot of the pitfalls that they see?
I mean, the indemnification language is always the key. The AIA contract is drafted by the American Institute of Architects, so their protections are always going to flow to the architect. A lot of people use the AIA contracts as a template, as a starting off point when they're drafting contracts between the contractor and subcontractor with nothing to do with the architect. So you have to really look at the agreement and modify the language to serve to best protect your client. And you want to make sure that you avoid the broad indemnification language that a lot of these agreements have. Under the broad form provision, you will have to indemnify the GC and the architect for any loss, regardless of who's blameless. So you may be stuck paying contractual indemnification based on a loss that occurred solely due to the architect or GC's negligence. Now, a caveat to that is that you have to know your state's jurisdiction. Every state has a anti-indemnification statutes. You want to know what your state allows for and what your state doesn't allow for, which is why you can't just take a template document and use it and think you're protected because it's the template. It's the go-to for the construction industry because every state will interpret it differently. When I'm drafting my contracts for my contractor clients and subcontractor clients, I always try and modify the indemnification agreement to be more comparative, which will it'll say that the contractor agrees to indemnify and hold harmless contractor from any and all claims, causes of action, damage, or liability, but only to the extent caused by the negligent acts or omissions of the subcontractor. That will limit the claims against your client for indemnification because they have to prove that you subcontractor were negligent in order to get indemnification. When you have that broad form language, they're coming to you every time there's a loss in the project, irrespective of who's negligent, and then you are stuck litigating that in court. You're being forced to hire a lawyer, pay attorney's fees, which I mean I like, but no one else likes that. As a lawyer, I like being hired and handling this, but there's a way to avoid it, and that's the smart way to do it. And I think that really taking the indemnification agreement, making sure it's only for your own negligence. And also, a lot of times the AA contracts only include one-way indemnification. So that means the indemnification rights only flow from the contractor and subcontractor to the owner and architect. If you don't make a change, then your client's not being protected, or your company's not being protected by the indemnification provisions. So you want to make sure it's a two-way street, so that the architect and the owner are required to indemnify you for losses that are caused by the negligent act or omissions of the subcontractor.
So here's one thing that I want to play devil's advocate for a second. So I'm hearing what you're saying, and it makes perfect sense. On the practical side, though, I'm a subcontractor. I've been trying to work for this general contractor for a long time. I finally got my way in. They're trusting me with this project. Now they hit me with their contract, and I don't want to turn it into a sea of red and send it back to them and sort of become a kind of like a pain in the ass, or a perceived pain in the ass. And then they don't give me any more work, or they put me in a situation where there's like a take it or leave it. So in your experience, how do you go about still protecting yourself and nuancing that aspect of it where you get what you need to, and you feel comfortable turning in some red lines?
So I had this issue arise recently, and the response I took, which was well received from the the developer, who is a client that my client wants to work with a lot in the future, it was well received by them, and we just all we did was change the broad indemnification to only caused by the extent of the contractor's negligence. That's one line, and it's only one line of red in a giant provision. The indemnification provision is usually very confusing, very long, and if they see you're only changing one line, they may not, they're gonna hopefully they'll accept it. And then what I like to do at the end is just add in a provision that just says that the contractor does not waive any of its rights to common law indemnification, because now you're not adding a new mutual indemnification provision, which will be long, complex, and confusing. You're just putting in that one sentence, and that reserves your right under common law indemnification, where depending on your state and your jurisdiction, you can get the same coverage you would get pursuant to the two-way contractual indemnification provision. And it's hard to find a contractor, a GC, or a developer, or an owner who you want to work with in the future that's not going to be reasonable and try and force you to give up a right you are afforded by law. Common law indemnification is created by law. So very, very, I would say that's the best way to find a middle ground, because you're going to say, look, all I'm doing is asking for what, I'm owed via the law. So the issue comes up is that a lot of times in the case in the scenario you're giving, is that if I'm representing the sub and I want to go back to them and say, hey, look, we want mutual indemnification. They say, no way we'll ever indemnify you. And then if you don't add that little caveat in the end about retaining your common law rights, they're going to go to court and say you knew that you waived all of your indemnification rights. And then, I don't think it's a winning argument because it's extrinsic to the contract, but it creates a problem. And this is about avoiding problems. Drafting contracts is about avoiding the problems, not and putting yourself in the best position to not be caught in litigation in a courtroom dealing with something you did not intend to deal with. And that's what you should be doing as a construction company, as a lawyer for construction companies. You need to really look at how this is going to be interpreted in court. So if the last communication between the owner and the owner and the contractor is that we will not give you indemnification, and you don't reserve your right to common law indemnification, there's a colorable argument that you waived that right. And while I don't think it's a winning argument, it could be.
Yeah. Well, when you're working with your general contractor clients and they send out their contract template and every sub just signs it without any red lines, are they more nervous about that sub or less nervous about that sub typically in the performance?
In the performance, I'd say we're generally more nervous. We're generally more nervous because it shows a lack of diligence. It shows a lack of, because look, everyone knows that if I'm sending you my version of the contract, I'm sending you the best case scenario for my client. That's like the dream wish list contract, where if someone signs that, they either didn't read it or they don't care. They don't know what they're looking for. And if you have someone who's just going to rush and sign it immediately, it kind of calls into the question their qualifications to perform the type of work they're doing and their knowledge of the industry, how long they've been around. You really sort of second guess their abilities and if they can really deliver on what they promised in their bid. So I think that, it's kind of double-edged sword, because you're very happy because you're like, this is the perfect contract for me. It's exactly what I wanted. This is the best case scenario for me. But then you have to try and use that. You look at that and say, look, this guy didn't read it.
Yeah.
How do I know he read the specs? How do I know he read the designs to come up with his bid? And he's not going to, hit me with $1 million in change orders over stuff he should have included in his scope.
Yeah, see, I think you're right. That's why I asked that question. And from your perspective, working with general contractors, that's why I think it's an advantage to you to read these contracts, or not, don't even read them actually. Just hire your attorney for a couple hours of advanced time. Proactive work is always less expensive and a great investment than reactive problem work on the lawyer side. And if you can spend a few hours of your lawyer's time proactively making these edits that Jason's suggesting here, not only is it going to be better for you contractually and legally if there is an issue, but you're also not going to be perceived in a negative manner. Matter of fact, you'll be perceived in a much better manner that you act and everything you are about to do and going to do and prove that you've worked hard for to earn this right for the client, the new client of yours, the general contractor. Now you're actually just solidifying that they're making the right choice because look how you're buttoning it up and you're finishing strong and you're starting strong and you're tidying up all issues. If you're paying attention to those details, you're also very likely to pay attention to all the performance details. And you pointed some of them out, scope of work, et cetera, et cetera. So I think that's a great point you made.
Yeah, I mean that's the key, and I mean there are a lot of other provisions we can talk about besides indemnification, which if you don't flag it, you're and this is something probably very near and dear and close to your heart is pay if paid or pay when paid provisions. That as someone who's mobilization funding, you're helping avoid the stresses and the negative outcomes that arise out of these pay when paid or pay if paid provisions. You're a subcontractor, you have to front a lot of money to get the work started, and you submit your invoice to the person you contracted with, and they have a pay when paid provision in their contract, and the owner is delinquent on payments to them, then your subcontractor is going to be forced to continue performing work without being compensated. And that's when delays happen, that's when defects happen, that's when a lot of issues occur.
Yeah. So how do you handle that? Like, so let's say the general contractor you're working for signed a paid when paid contract with the developer. And, they're just sending that same contract payment language downhill to every subcontractor. How do you position the general contractor to go at risk essentially in a manner that they're not willing to take themselves or they're contractually bound not to take?
So I try and be as specific as possible in my contracts when I want to make I like to put in there specific deadlines for payment requisitions to be submitted by my client to the contractor or the party upstream from them. And then I like to include specific language that when that requisition will be passed on to the owner. And that way you start a clock and you make sure there's a timeline. And while they may have pay when paid, you can then force them and say stuff like, "Hey, this was sent to you on this date, when you were required to give it to the owner on X date, and you have to do it." I mean, sometimes you can try and force language down the contractor's throat where they may not be willing to agree to. You say payment due within 45 days, regardless of owner payment, and the thought behind that is that the GC is usually a bigger company, and they're more likely able to make the payments to you and not the smaller subcontractor who can't live or can't do the work without it. So even if there's a pay when paid provision, I like to include, if I know there's a pay when paid provision in the owner contract with the GC, or I like to make sure I put something in there is that you have to pay us within a reasonable amount of time, 45 days, irrespective of the fact if the owner pays you. That protects us, and then you can sell that to the contractor because you said the GC. So we're giving you 45 days. Then the burden falls on you to chase the owner and get paid.
Yeah.
So it's a burden shift from the contractor to the GC who has to chase the money, because you don't want to be the subcontractor chasing the money. You have no privity with the owner. You can send them emails. You can try and go up to them on the site and say, "You got to make a payment to the GC. I need to get paid." It's probably going to fall on deaf ears. When the contractor, the GC who's in charge of the entire site, and is a bigger company who has probably a good working relationship with the owner, they're going to listen to them, and you're going to require payments to be made on a more timely fashion, not only for you, but it'll probably help other subcontractors on the project get paid because they're going to be hounding the owner for payment, and then the money's going to flow downstream.
Yeah.
So
I like that suggestion. Two of them. One, if I'm going to summarize, I want to make sure I heard you correctly. One, if you can get the clause of 45, 55 days, then great. Excellent. Most likely that's going to get pushed back on if they're in a paid when paid contract themselves, because they're not going to want to take that risk. But if I understood you correctly, the check down from there is, okay, well, let's prevent it from not being submitted that caused the payment delay. And I've seen that a lot in our world with our clients where they submit everything on time. The general contractor is trying to work with their other subcontractors to get their recs. And it's because there's a clause in their contract, or more likely there might not be a clause, but the developer's bank who doesn't understand typically anything that goes to that, and they don't care because they're so far up the chain, they are actually a problem because if you don't submit it to them on time, you only have certain time frames, and they know that it's going to take the bank 7 days to turn it around. So they want to get the structural scope in their AIA, and they want,
Hmm.
or in their pay app, and they want to get the electrical and the mechanical and all that. And then you're just another trade waiting, and you did everything right. By just putting in that language, it at least contractually obligates them to submit it. Or you have some contract clause in there that if the electrician hasn't turned their stuff in and the GC and the project manager are waiting on that electrician because they want to get the AIA in, it's not delaying you 7, 8, 9, 10 days, or you can try to at least limit that.
Exactly. And then, sometimes when you start forcing good habits on the GC, those habits then spread to other subcontractors. Like, as you and I both know, my client can't control what the HVAC or whatever MEP contractor does. But if you have a 10-day deadline to submit the bills in your contract, they're going to abide by that. And the GC is going to want, like you said, put together one larger request for funding. And that's going, that way you can force everything to be submitted at once and good habits spread. And then hopefully everyone gets paid in a timely fashion.
Another clause that we see a lot, and I'm curious your opinion on this. You can't stop work. If you stop work, it's an automatic termination, right? And so if you're not getting paid, what can you do? Well, I'm not going to show up. Okay, well, as soon as you don't show up, now you can get terminated, which means the 45 days of work or longer that you haven't been paid for is now going to be held, right? Or so can you put clauses in there, or do you see them generally accepted by general contractors from a practical sense? Whereas, like, if you're not paid within a 60-day period of time, that you have the right to not work
I
without being a clause. Can you, or whatever the right termination, whatever the language might be, can you put things like that in there?
it's not a term. I like to do suspension of work provisions. It's sort of born out of the AIA contract, but a suspension of work where you say I'm the contractor. If I timely submit my payments as at my payment request as required by contract, and I'm not paid within 60 days, I can stop work. And then until I'm made a payment is made to us, then then we'll have to remobilize and start working again. And having that language in there, hopefully it never gets there. I mean, we can both say hopefully payments are made in a timely fashion, and you don't have to worry about this. But let's be real, it may happen. But
It's going to happen in your construction. It's going to happen in your company's life at some point. There's no doubt
exactly,
about it. Yeah.
if the GC knows that some subcontract has a right to suspend its work, and they're gonna go to the owner who they have the privity with and force payment. So I think that really being creative and being smart and how you phrase things, I mean, it comes down to how you can present it to them. You can present and say, look, I want to be able to stop work and walk off the site if I'm not paid within 60 days. You're gonna get a ton of pushback in that. They're gonna say that's not a proper termination provision under the contract. It's fine. I don't want to be terminated. I want to keep working, but I'm going to suspend my work. I mean, you may have to make some concessions in wherein you'll be required to eat remobilization costs, as they won't be, compensable delays, or compensable, but it sends a message along that you're willing to eat that in order to keep the project going.
Yeah.
And you want to put the GC in the position where they're like, if you don't agree to this, we're not being very reasonable, and this is going to be a problem. And then hopefully, and then they can hopefully. I've had good success in getting language like that kept in contract. I've had cases where they've redlined it completely out. So
Yeah.
it really depends. But if you don't ask, you never know.
Yeah, you know what I think it does though too. At the end of the day, like these aren't like it's not like an argument over contract language because at the end of the day, what it all boils down to is just humanity. It's
Mhm.
it's two humans trying to talk. They're uncomfortable about something on the project site. The project manager, regardless of you never know where their stand is inside their own organization. Do they got a lot of juice? Do they have no juice? Are they on a performance planning because no one trusts them, and so they don't want to go say, oh, my contractor wants to get paid because so they don't do it. You just never know those kind of things. And so putting these clauses in gives you some contractual piece that actually will force another human being past their comfort zone at some period of time, which is really, at the end of the day, practically speaking, all you really need. And you need, at the end of the day, when you start working, it's what's written, not what's been said. So you got to
Yes.
have something written that allows that other human being to push past their level of comfort. And I think if that one, if you can just get those one things done to force, that'll provide a lot of practical problems that occur on a construction site between a sub and a GC to go away, or at least be handled.
Yeah, I mean that's all you want to like. You're right. All you want to do is get someone to do more than what their job, like what they think their job is, where they don't have to just forward over. They're not just forwarding over the payment recs and sitting on their hands and doing nothing because in their mind they've done what they've had to do. But if they know there's a real threat that there's a suspension of work and the GC probably has a liquidated damages provision in their contract or some kind of damages for delay clause that if they're now if that subcontractor is going to suspend their work, there's going to be delays in the project, which could really cause the GC a lot of money. And then it forces them to really keep sending that follow-up email. Hey, we submitted this on June 17th. Let me know when we can get payment. We need payment before July 1st, or we run afoul of a suspension language, something like
Yeah,
that. Those check-ins are what's going to get the person to respond. Sending one
exactly.
email that gets lost in, you get 180 emails a day. One email may most likely will get lost if you're not consistently following up.
I love that. All right, I'm going to transition in a little bit here. You've dealt with some major issues and defects on projects before, and you understand how that trickles down to everybody on the site and can create problems and issues. What role does vague or missing contract language play in these major problems and issues, and how it impacts the different players in the subcontractor world?
So the first way I'd respond to that is the vague language in contracts where a subcontractor agrees to, perform work that's outside their scope. I mean, I've seen a plumbing contractor get a contract where it's, the scope of work will include all work necessary to obtain a certificate of occupancy or a certificate of completion or a certificate of substantial completion. Does that mean that the plumbing contractor now has agreed that the scope of their work is to make sure all trades complete all work necessary? I mean, between you and I, the answer is no. But between the court, when every court in the country likes to enforce contracts as written, and they're going to come into court and say they knew that their obligation was to make sure the building got this substantial completion or obtained a certificate of occupancy, and they didn't do that. So the vague language is always a problem. We can talk about scope of works. I like to keep as detailed as possible. I don't like language like first class work. I don't like proper workmanship. I like as required by the specifications of the specs of the project.
Right.
That way, because what does a first class project mean?
Right.
I don't
And
know.
who defines that? Right.
Generally the owner, when they're going to
Yeah.
raise a dispute, they're going to say first class means that nothing's ever going to go wrong.
Hmm.
But if you let's say you're doing concrete, you want to cite the ASTM standards, and you want to you want to keep that because that way you could say I've complied with the standards I agreed to comply with, and it's not work. It's not in a great workmanlike manner. It's pursuant to fungible actual standards. And once that's incorporated, you have now protected yourself from potential scope issues and all the other kind of issues that you're going to reach on change orders
Hmm.
and whether they're going to come back and say you need to do more than what you've done.
I love that. All right, let's talk about change orders. How do you manage change orders in a contract? How do we isolate that scope? How do we make sure we can get paid for them? How do you make sure you're not doing the work before you're paid or at least agreed to? I mean, all of these things are practical problems that happen. And doing a change order work sometimes has to happen because it's a change. It has to happen before you can even progress. You can't
Mm-hmm.
just cover up a wall that needs something done behind the wall. So it kind of has to happen, but they don't. So how do you handle these things so that you can ultimately get paid? There's agreed upon scopes of work. Like, what is the way to do it?
So what I do is a lot of people may not like this. I like to create an initial decision maker. So it's generally the architect. And that way, let's say what if I classify something as a change outside of my scope, I have to submit it to the architect for them to verify whether it's within or outside of my scope. And and then you have something in your contract is if the architect or initial decision maker finds that it's a change order or it's outside the scope of your work, owner agrees to compensate that. That way they may not pay you right away. You have something in contract that says that this third party said that this works outside the scope and that we should be compensated for it. And that's an agreement. And the agreement is it's a separate, almost creates like a separate agreement within the contract. Because now it's a way to make sure, because like the problem is some contractors may be a little greedy. They may try and fudge it so some scope work is they can classify as change order work, and the initial decision maker snuffs that out, doesn't allow that. But when it's
Mhm.
legitimate, the architect or engineer, whoever you choose, is gonna say this is a legitimate change order. So that's how you can sell something like that to the owner, because that way you could say, the owner, look, hey owner GC, if this is not a change order, they're gonna say that, and then we waive our right to submit this for a change order. However, if the initial decision maker says this is a change order, you waive your right to claim that's within the scope of our agreement, and therefore you have to compensate us for that work.
See, I like that a lot though, because I like taking it and putting the burden of the decision somewhere else. Now, let me ask you a question though. So you're putting this in your contract with the general contractor. Let's
Yes.
say the general contractor though doesn't have that change order language in there. It's change order like when approved, the owners and the GC's contract is when approved change order, it's approved by the owner developer, right? What kind of pushback is I mean, it makes total logical sense to me, and I think it's actually a great way to manage that. But how does that work out in reality when the GC doesn't have that type of same change order language between them and the owner?
I've had that argument presented to me, and I say it's a lot easier for you, GC, to go to the owner and convince them this has to be an owner approved change when a third party, i.e., the architect, agrees that this work is outside the set of plans that the architect probably created, or the engineer. The engineer or architect probably designed it. And if they're coming to you and saying that this work that we're asking them to perform now is outside the work of the contract, the owner has to agree to it.
Yeah, and it's the architect's hired by the owner sometimes, or it might be maybe the GC hired the architect
yeah,
too. But at the end of the day, some other party other than the sub hired the architect, and it, in a world where it's never clean, it can never be super clean. I do think that's great middle ground, and I haven't heard that suggestion before. But and you find that successfully usually input into contracts for change
yeah.
orders.
I found it successful. As we speak, I can see the pushback on it, obviously,
Mhm.
but I found it to be successful, and I found it to be because you also have to figure like the owner and the architect. The owner is paying the architect, even if the architect agreed with the GC, they're still getting paid by the owner. So you can argue there may be a conflict of interest there that the architect may want to limit scope, limit the change orders to appease the owner so that their relationship continues. And then, you include in there that the architect is then liable for any improper classifications, and then you retain the right to litigate it later. And that kind of forces the architect to be more, or whomever you're choosing as the initial decision maker, to be, having to be a little more reasonable and kind of forget the conflict of interest and who's paying them. Because if they're just saying everything's within scope, they can get sued later for what you're claiming is improperly classifying change order work as scope work, and then they're liable, and then it's a whole other issue the architect probably going to want to avoid.
Yeah, and I think you made a good point too. And being fair as a subcontractor, you really should stick to submitting change orders that are actually real change orders too.
Of
And if
course.
you build a reputation of submitting change orders that are change orders, and they get approved, then you're going to get a lot more leeway in these things too. And that doesn't mean you're submitting every little nickel and dime change order, but you do want to protect yourself from these big change orders that could occur that then prevent work, which then
Mhm.
kick in, I can't keep working, or I'm paying out all these costs, I'm not getting paid, it's not being settled, the disputes there, and now you're getting into the termination language and the change of the inability or ability to walk off or suspend work, and you're getting hosed because it's a lot of times not just your regular scope of work, that's not getting paid. It's your change order work that's not getting paid, which then
Yeah.
leads to you not being able to submit your normal scope of work contract because the change order work has to get done before you can do the regular scope of work. And everybody understands what I'm saying that's in construction. So this is like terms that working these out up front when everyone's excited before there's a shovel on the ground is the time to be managing this, not midway through the project when there's way more problems occurring. But I love your suggestion. I think that's a great one, and I'm glad to hear that in practice you see it accepted often.
Yeah, I mean, it takes a little bit of time. It takes a little bit of negotiating. You're doing, I like to consider, your lawyers probably consider themselves to be good negotiators. And if there's a way to phrase every change, every tough negotiation can be broken down in a way that it shows the fairness for all parties. And if you can get to that part where you're explaining why this is fair for everyone, and I think with the initial decision maker that I mentioned, you can show why that's fair to everybody. And then you kind of put it like, why would you not agree with this? Or is it because your intention is to not pay for change order work? And that those kind of like little comments can, either throw up a negotiation or it can kind of push it over the edge. It really depends on your lawyer's style, your style, and the way negotiations have gone.
The other good thing about having the architect or engineer do it is they have insurance policies, something else you could go after that isn't a single entity LLC that was perfectly insulated
Yeah, of course.
from being sued, and that's a great it's a little sidebar for subcontractors out there that there's a real insurance policy that would cover that kind of stuff. All right, mechanics liens. Let's talk about those. They're a hot topic. A lot of times you can miss the boat on your mechanics liens. You can try to get it. You have your suppliers, you have your subs. In general, what is the best practice for making sure you're maintaining and preserving your lien rights and your vendor supplier lien rights as associated to what's under your scope of work?
I mean, this is going to be you're going to say it's a cliche answer, but the answer is being organized. I like to go to my clients and say, you need to have a chart. You need to have a chart that says what exactly the invoice number, what the scope of that, what the invoice number relates to, what work, date submitted, then date paid, the amount paid, and then have the same thing for material and suppliers. Date invoice provided to you, date you provided to the contractor or your contracting party, and date paid. And if you're a subcontractor using a material supplier, I mean, you mentioned lien waivers earlier. You require a lien waiver. You say, look, let's say you had to deliver, rebar to my job site, and that's a supplier. When they make their first delivery and they're paid, you with the payment with the wire, you send over a lien waiver and require that to be signed and returned before any other payment requests are processed.
Right.
That way, you protect yourself, and then you have to be, and then keeping yourself organized when you're going against the contractor in the GC is key. And then knowing your deadlines. I mean, I do a lot of mechanics lien work in New York. I can only speak to New York law on this, but every state, every jurisdiction has different deadlines to filing. On a public project in a private project in New York, you have 8 months from the last day you performed work or provided supplies to file a mechanics lien. In Pennsylvania, it's 6 months. In Florida, I think it's like 90 days. So know your jurisdiction. Know when your deadline to file is, and know how, and then be able to very clearly determine what work wasn't paid for. So that's where the chart comes in. If you have, invoice one for 100 grand, they paid you 100 grand, to take all that stuff out of the mechanics lien.
Yeah. What's your thought process on using outside services like a Level Set or a Procore or other, companies that can process the notices to owner? They stay up to date with all the jurisdictional issues, counties, and I mean, all, like you said, every state, every county, every city, they can all have different lien rights versus doing it yourself. What is your thought process on that?
So I don't oppose when my clients have a company, outside company, like some of the ones you mentioned. There are some other ones in New York, but same kind of companies do the actual filing of the lien and the docketing. But your client has to take ownership of the amount you're claiming. I mean, New York specifically, there's something in New York lien law, there's willful exaggeration. And that if a court finds that you violated the lien law and you willfully exaggerated the amount that you're owed under the contract, let's say you're off by a couple hundred grand, they'll strike your lien and then you can't refile it. So you lose your right, you lose your lien rights. And if they found that you willfully exaggerating it, the subcontractor has to pay the owner's legal fees for the striking of the mechanic's lien. So you have to, while you can use outside companies to do the tracking and the filing, that you or your clients must take ownership of the actual amount, the scope and the amount of the mechanic's lien, and you have to be verified. And that there's the other thing is don't rush to file. Like you know your deadlines and then take that time to really determine how much money you're owed. Make sure you're not asking for general conditions or retainages if a contract says you're not entitled to that. Make sure you comply with your contract terms and have a good argument where you can say that there's no way we willfully exaggerated this lien, and then you can use an outside company to file and docket it. But really, I can't stress enough to take ownership of the amount that you're filing for, because that losing your lien right for $1 million is really bad. I mean,
Mhm.
and then you're just filing a normal breach of contract claim, and then or usually there's no breach of contract. You're filing a quasi contract or the unjust enrichment or quantum merit because you have no privity with the owner. So you got to be very careful. And I know other jurisdictions have similar provisions like the willful exaggeration in New York. But again, just know your jurisdiction, know your amounts, and make sure you're very, very specific and take your time and to really categorize and figure out what you're owed and what you're not owed.
So a lot of times, one of the other things that comes into play with like mechanics liens and getting payments and lien waivers, a lot of times some contractors are required to submit lien releases from their subs and suppliers prior to being paid. And the practical knowledge would say, well, I can't pay them until you pay me. And the GC says, well, tough, figure it out. And so what can you do in those settings, or what do you do in terms of the contract language around that can either help prevent this issue from happening or put getting paid GC to subcontractor in more practical terms to the way the reality actually works, meaning it takes the money to be paid to me before I can pay the subs. Now, the GC is going to say, well, I want to make sure you actually give them to the subs and you don't do that. So therefore, I don't trust you. I need the lien releases in advance. Like, what is the solution?
So my solution that is to say that to do a deadline, all lien releases will be provided within 5 business days of payment of the final requisition of payment. And that way, if you don't, the GC is protected, because if you don't provide that document, they can say you didn't pay them in full, and then they have ammunition against the contractor. But as the contractor, practically speaking, once you get paid the payment from the final requisition, you should be getting all lien release. You should be paying all your your suppliers, all your subcontractors, all your laborers. Everyone should be paid once that final requisition is paid.
When you say final, do you mean the final for the job or you mean the final for that pay period?
Final for your scope.
Scope. Okay.
I like to require partial lien waivers to be given within 5 days of payment, and then there's the final lien waiver, which is usually the biggie.
Mm-hmm.
That's what they come into court waiving when they have a mechanics lien case. Say, no, you were paid in full. Here's a lien waiver, and look, you signed it. And so I like to, for that one, it's 5 days within final payment. And also for progress payments, same thing for progress payments. Within 5 days of a progress payment, subcontractors shall get a partial lien waiver from suppliers and subcontractors and submit it to the owner, the GC. And 5 days is a short period, and you never know when someone's working. You can agree to extend it to 10 days and whatever you need, but they're going to want to keep it tight. They're going to want to keep a short deadline because they want those for their files to protect them if there are suits for unpaid money where they paid it before.
This is one of those things that in the subcontractor world, you got to give to get. If you can't, at some point or another, if you have to rely on your credit from your suppliers to help finance your jobs or the other jobs, this is how you can get bit hard when
Oh
you
yeah.
have a problem on a job or a change order. And the things we're talking about here are tough to have. These are tough conversations. You're like, well, how the hell am I supposed to finance my job if I can't leverage my supplier terms? Well, the problem is at some point, and if you look over a 5, 6, 7, 10-year span, you look at all these construction businesses, if you talk to those owners and sit down, they'll tell you the year that they weren't profitable or the year that all of a sudden something went wrong, it's the one bad job that bit them. It's not that they didn't know how to do the work. It's not that they didn't perform. It's the one bad job that bit them and either wiped out all their profit for the year or multiple years, or created a massive lawsuit that created more expense and you didn't get paid. And if you could just do these other things here, this is the type of stuff that'll protect you from like disaster. And that's where I wanted to hone in on with you, not only in the contract languages, but also how you manage these lien rights, but managing the fact that like you got to be able to give to get and like running it tight. And then sometimes this will just sort out like which customers you should work with too.
I mean, just kind of based on what you're saying, if I'm entering into if I'm a contractor, I'm entering into contract with subs. I'm including limitations of liability language in my contract, saying that I'm only liable to you to the 100% of the contract. So you're not stuck with those gigantic losses, and then you waive a waiver of consequential damages. You want to have that in there too. If you're the contractor subbing out work to a subcontractor or a subcontractor to a subcontractor, you want to have those protections where you're only limited to liability to the amount that is actually in play for the project.
So true. Jace, what else should we be talking about that I have not asked you that you comes up a lot and we haven't discussed today?
So I guess really quickly, force majeure clauses are big. I guess being able to determine what's a compensable delay and what's a non-compensable delay, and making sure that if there's, let's say, a hurricane that affects your work, you have that built into your project where, while maybe it's not compensable, you're given a time extension to complete your work. So, I mean, I had clients that were destroyed by the last hurricane. What happened? There was, I know in Florida there was in St. Petersburg there was the crane collapse that definitely would have set off and created a whole host of problems. And if your force majeure provision is not broad enough to include stuff like that, you're getting the short end of the stick. I mean, force majeure clauses, at least in New York, are very narrowly interpreted. I mean, the case law in New York is that even the COVID shutdowns were in force majeure.
They were or they were not?
They were not.
Oh, wow.
So that's why you want to be, when I'm doing contracts now, I'm including in force majeure labor shortages, tariffs, because tariffs have a negative effect on the supply chain. So if I'm importing goods from other international companies, I need to have protection if the process is going to take longer because of supply chain, because of tariffs. Whether there's you want to be able to be protected and have a non-compensable time extension for that the customs delay. There's going to be custom issues because the government's going to want to make sure that you're not using an intermediary and getting materials from a higher tariff country through somewhere else to save money. That's all going to take time. Right. So I like to, when I'm doing my force majeure clauses, I've recently added tariffs. I've added labor shortages because due to certain things that are happening around the country are affecting the workforce, the availability of the workforce, and the availability to obtain materials. Now, owners and GCs are not going to be willing to compensate you for that delay, but that's fine. Just take let's say it's 2 weeks of the materials are stuck in customs. That gives you that 2 weeks back as if it never happened. And that way you can perform the work and not rush. Because as you and I know, when you start rushing construction work, that's when defects come in. That's when everything falls apart. That's when there's cracks in the foundation. That's when water's getting in. A ton of damage occurs, and you have defective construction lawsuits in 10 years. You avoid that because you're not rushing, because you planned ahead. You're aware of what your contract needed to say, and you're positioning yourself to best be protected by your contract. So I think one major point is that you can't. A contract's a living organism at this point. You have to review it every year. I meet potential clients who are like, I haven't I had to dust off my contract that I used 10 years ago. I was like, you can't, so much has changed in the construction world in the last 12 years since I've been involved that you have to constantly be amending it to protect yourself because using what protected you in 2010 is not going to protect you in 2025. And
Yeah.
like you said earlier, it doesn't hurt to send it to your lawyer. Send it to a lawyer to look at and say, I need you to do an overview of this contract. And you can do that once a year. That lawyer will review it and say, this is a good template contract for you to use. And then if you trust yourself and you have an internal contracts people, they can take that and begin, use that and modify it per job. But you want to have the major key provisions that you're going to use perfected
Yeah.
and perfected to the way that you have a best case scenario, a middle ground, and a worst case scenario. And you want to be planned out for each one of those situations. That's what I
It's
tell my clients.
especially if you're doing different scopes of work or different types of projects. I mean,
Mm-hmm.
if you're doing painting and stucco, for example, on high-rise condominiums with a certain contract template, you don't want that same contract template you're using when you're doing like a Starbucks remodel.
Yeah,
You
of course.
need more terms in it. There's more bombs. So those are the kinds of things that can get overlooked in just regular business as you're hustling. It's all about like grab new customers, do more work, make more money. All that's great, but these are the little things that will also help you allow you that work to be done to make the money you're intending to.
That's
I
yeah. I
love
mean,
it.
like you said, an hour or two of your attorney's time, where it won't hurt your deal. You come to terms with let's say a Starbucks, and you only have like a painting remodel contract you want to use. Send it over to your lawyer. Say, take 2 hours, flag any major issues. If there are no major issues, make your revisions and get it back to me. That way, your lawyer will look at it from a high level and say, this is what this is okay, but as long as you include these terms, and you can feel confident, and it's a quick turnaround, so you're not going to lose the client. And
Right.
I think in this industry, a lot of people are afraid that if you delay, someone can swoop in with a better offer, and then you lose the job. If you keep tight deadlines and you have responsive counsel, you can avoid that and you stay protected. And then if you listen to this podcast and know what you're looking for, you can do that yourself and at least get a head start on it so your lawyer can spend even less time on it. They'll bill you less for doing it. You'll save money there and you'll have the contract you need that's going to give you the best protections.
That's right. That money you're going to spend proactively will be 30x minimum the second you have a problem before that you get started. It'd probably be 100x by the time it's done, but the money you spend proactively will be minimum 30 times more just
Mm-hmm.
as soon as there's an issue or problem. That's not even counting the money you don't get paid. That's just the attorney's fees.
Exactly.
Well, Jason, I really appreciate you coming on the show. This has been an awesome conversation. I'm excited for folks to learn and get this like practical knowledge in an easy, simple way for them to put it into practice, know where to go. How can folks get in touch with you? How can they help you? Yes, you can help them in Florida and New York law, but really you can help practical conversations for any client across the country. There's a lot of different contract law. You can't write their contracts, you can't be their lawyer, but you can help them, and you can also probably help them find the right lawyer or even give them some opinions. So, how can folks find you? What's the best way?
So my email is JKOSEK, so J Kozak at andersonkill.com, ANDERSONKILL.com. And my number is 212-278-1028. Call me, leave me a voicemail, I'll call you back and you'll get my cell phone number because I give everyone my cell phone, but I don't want to give my cell phone number out on this. So if you call me on that number, you'll get the 𝗏𝗆𝗆's number, which is my cell phone. I always answer that.
I love it. And I know you can find you on LinkedIn too. Any other social media channels that you operate from?
No, no, nothing else, nothing for me.
Well, dude, I think this was an awesome conversation. You broke down some complex issues in a good, nice, practical manner that I know people can grab onto, take their notes, and they can do some things and execute from here. So I'm really grateful for that. Thank you very much.
Thank you for having me. I really enjoyed the conversation.
All right, everybody. I hope this helped you a lot. If it did, Please share it with your friends. Give Jason a follow on LinkedIn. You, of course, can find me on LinkedIn as well, and mobilizationfunding.com. Our YouTube channel also is Mobilization Funding. And in the meantime, everyone, until next time, have a great week, and may God bless you.